does not even need, but regularly exercises this original and exclusive jurisdiction for citizens of this country. Second, Article 130 provides, 131, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution. The Supreme Court shall have exclusive original jurisdiction and in A, all matters relating to the enforcement or interpretation of this Constitution. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or persons by law or under this Constitution. Where an issue that relates to matter or question referred to in Clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. This means that if anyone finds that a meaning is being given to any provision of the 1992 Constitution that the person disputes, or that any act is being done by reason of a disputed meaning given to the Constitution, then Article 2 and Article 131A mandates that only the Supreme Court has jurisdiction to provide the people of Ghana with the correct interpretation of the provision in the Constitution. Third, it is the most basic tenet of our legal system that different courts operate different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of Parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of Parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court, the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution. And every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether a person has been validly elected as a member of Parliament, or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament or a seat of a member of Parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed by reason of the meaning of Article 97(1)(g) to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g). It has been argued by counsel for the Speaker that what the Speaker presented to Parliament on 17th October did not constitute a ruling that was executable or amenable to the controversy raised in this suit. On the contrary, we find that nothing can be clearer in the record from Parliament that was brought to this court and considered before this court's ruling of 18th October 2024 that this was an executable ruling. The Speaker's ruling is headed, quote, formal communication by the Speaker. It set out the background of issues he was considering and covers 10 pages of evaluation of law and fact. He concluded by declaring that, quote, the MPs cannot be allowed by law and my good self to continue to pretend to be representing people that they do not believe in and have no loyalty for in this House any longer. The House is accordingly informed, unquote. These are words that affect the rights of these MPs to remain in Parliament and the rights of their constituents to their representation. Thus, if a controversy is raised to the propriety of the interpretation of Article 97(1)(g) that led to this conclusion, then this court is rightly sized with jurisdiction to provide a hearing. According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next Parliament and not while sitting in the 8th Parliament. These and others are the disputed interpretations that the plaintiff presented to the Supreme Court to give the nation the correct meaning of. For the sake of the record, we set out Article 97(1). A member of Parliament shall vacate his seat in Parliament upon a dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. Or D, if he is expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. Or F, if he resigns from office as a member of Parliament by writing under his hand, addressed to the Speaker. Or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2, notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of parliament. Now, clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes of the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breach the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024 in hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Amenfi Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker, the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance, arising from the outcome of the ruling, weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second Deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g). grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004, CI 47, that enjoins High Courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte, and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Lord, we are extremely grateful.
Ask the court, please, Ismail.
So, Mr.
Grateful.
So, Mr. Sorry, will you be filing anything? Or should we hear without you?
Oh, no, I don't have instructions on that matter, but especially so that if my lady looks at the affidavit that I filed, I said the order was served on the Speaker on Monday. So he has 7 days. I'll speak with him to draw his attention to the court's ruling. And then
so it was served on him on the order was served on him on Monday.
That's Monday.
Monday was 29th?
No, last Monday is the 20th.
Monday, just around 2 weeks ago.
No, wait.
No.
On the 20th. It was served on the 20th.
On the 20th?
No,
and today is the
21st. It was 21st.
So he's gone past the 7 days?
No, but if he's served with the order on that specific day, telling him to file within 7 days. It takes effect on the date of service. That is my understanding.
So he was supposed to file by 28th?
No, by the rules of the court, where the time limited for doing something is 7 days or less, weekends are...
So he was supposed to file by when?
If we check out... No. Today.
Today?
Yes.
This suit is adjourned to Friday for completion. File your processes by close of day tomorrow. This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this suit is to enable parliament sit. It's to declare...
Very well. Yes, I take it that's really in your...
So if I would plead that because this is, look at the time that we are closing and the fact that we've done some work, filing it by Friday is not, it's not possible. I also need to still go and take instructions. So maybe next week is fair. Today is Wednesday.
All right. Next week.
At least if I'll take 7 days to file the 2.
No, do not count your 7 days today. Your 7 days started running from 21st. You cannot make your own rules.
I'm just praying the court. I'm not making rules. I'm just praying the court.
So you will file by what date?
By Monday. No.
Lady, respectfully. Right. Yes, very respectfully, there are 2 points that arise out of my reference and brief submission to the court. And I made them. 1, this is a matter for the interpretation of the Constitution. Respectfully, as I earlier on submitted, in the matter involving the interpretation of the Constitution, there's even no such party as a party who has an interest in the matter, apart from the entire state. Respectfully, it is not for nothing that the Constitution makes the Attorney General the defendant in all actions involving the government, an arm of which is Parliament. Respectfully, my submission is that
and the Constitution.
And the Constitution, yes.
In all constitutional actions, the Attorney General is required
to be a
party.
Yes, to be a party. And respectfully, the point I make is that indeed the reluctance, with all respect, of the first defendant.
Can we get to know the objective?
Right. That first and foremost, if the first defendant is unwilling, with all respect, to file processes to enable the court to complete the case by Friday, my submission is that the first defendant is not even a proper party.
But also expects the court to set aside the processes and proceedings which led to
complete the reading of SBD, if you want to.
No, my lady, you said the point was made and I was bearing to it.
Very well.
Yes, so I'll do it. So, the basis of paragraph 49 yes, my paragraph 49 arises from the observations made by the court before its ruling on the basis of which it made the orders. And
your paragraph 49 is premised on observations by the court
made in the course of its ruling
in the ruling of
18th October, which is sought to be set aside in this application. in the 4th page of the ruling of the court, starting from the 3rd paragraph.
Attached us.
Yes.
Attached us.
Exhibit B. There is a finding by the court that the applicant or the court observes that the applicant urges, and we appreciate that the said ruling would also likely lead to alleged thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruptions. And so the court then, on the basis of that, makes its ruling in Exhibit A and notes that.
No, hold on.
Point also, yes.
Hold on.
Yes.
So the partisan political aspersions arise from the observation of the court on the submission of the applicant in that time.
Yes, my lord.
At that time.
Yes, my lord. Because in the ruling of the court, if my lady looks at the 2nd page of the ruling of the court, I think if we start from, the court makes the same observation. Exhibit E.
Exhibit A is not the ruling of the court.
No, my lord, those portions of the submissions that were made to the court were relevant and that informed the ruling. That's what I'm saying. Yes.
Not exhibit A.
Yes. No, those were the proceedings.
Yes.
Mr. Sorry.
So it is not. Your
court
is not the ruling of the court.
Gun.
So just refer us to the proper exhibit, which contains the ruling of.
Yes. So I started from the proceedings and I'm now ending with the order. The order also the order just makes the same finding. If my lord should take a look at the paragraph that says the applicant urges the court.
Where are you reading from?
After listing the parliamentarians affected by the ruling, there's the next paragraph which starts with the said 4 constituencies, and then it goes on to say the applicant urges, and we appreciate that the ruling.
So you are reading from Exhibit B.
No, just check A. The order that was sent. Yes. Yes. The cover letter is marked A, but attached to it is then the order of the court.
Mm-hmm.
And so that was taken into account before the court then makes the extensive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex parte application, and they were heard. What was the balancing?
Sorry.
Yes.
I thought you were just responding to a very straightforward.
Oh, yes.
Thing. But now it appears that you are veering into the substance of the motion itself.
No.
I would urge you, rather, to restrict yourself to the objection that he raised and answer it, whether it is scandalous or it's not scandalous.
It is not
because
scandalous.
My problem is,
yes,
if your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My lord, I needed to demonstrate that these things were not just said out of any.
No, just restrict yourself.
Oh, my lord, that's exactly. I thought I was doing that.
Yes.
And so, insofar as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before the court.
You allege that the Chief Justice is privy to a breach of a constitutional provision. What are you trying to convey?
It may have been by reason of inadvertence. But if that is a statement of fact,
was it necessary for you to add that in your depositions? For you, what exactly were you trying to achieve by adding the point that the Chief Justice was privy to a constitutional breach? I think that's the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
But Mr. Sorry, the ruling, if you don't mind, let me draw your attention to the fact that the ruling says that if you look at the first page of Exhibit A,
Yes.
we note from Exhibit B the official report on the parliamentary debates on Thursday, 17th October 2024, pages 15, 16, and 17, that the Speaker of Parliament was aware that bailiffs of the Supreme Court had served the current action on him through the legal office of Parliament. His objection to this proper service of a process from the Supreme Court was that it had not been done on a Monday.
Yes, my lady.
That's what the ruling says. So hold on, please. So the ruling was quite clear. The source of the notification.
Yes, my lady. But that's even the source.
If I could land.
Sorry, I thought my lady had finished. I'm very sorry. I thought my lady had finished. I'm honestly sorry.
Yeah.
Should I?
So the ruling was quite clear about the source of the observation that the Speaker of Parliament had been properly served. And the ruling appreciated the circular, administrative circular from the Chief Justice. The first Chief Justice was Chief Justice Edini Eboa in 2021, and myself issued another circular which clarified how all of Parliament was to be served. That is what you are referring to. Is that not so?
Yes, my lady.
And how does that veer into a partisan political agenda, including constitutional breaches?
The two are independent. Let me deal with the first one. My lady says the finding even by the court that it was proper service is the point we are making. That by reference even to the parliamentary proceedings that took place that day, it was clear. It is not, first of all, it's not the official report because it was just a draft one. Parliament had not yet gone through it and adopted it as an official one. 1 minute. But the second thing is that the court could not have found without referring to the judicial circular in which the proceedings had indicated clearly that the first defendant was objecting that it was not in accordance with that. And the plaintiff appreciated it. So that is it. And this other, with regard to the partisan aspect of it, that one is distinct. It's a distinct point, and that one is based on the submissions made to the court that, based on the assumption that if one party is the majority, it is deemed that government business will be thwarted. That's based on that assumption. Because if the Speaker's ruling state, there was nothing to show that whichever party was the majority or otherwise, government business will be thwarted. And the Constitution doesn't assume that the government in power would necessarily have majority in Parliament. So those were the issues that were raised clearly on the face of the documentation.
Sorry. Are you still addressing the preliminary legal objection raised by the attorney general, or we are dealing with a substantive matter, i.e. your motion to set aside the process?
Oh no, I'm dealing with that matter, but I'm also responding to questions from the bench, showing why, if my lady says that it was based on the proceedings in Parliament, I'm answering that.
Kindly round up.
Yes, so my lady, there's nothing scandalous about it. They are based on matters of fact that arose out of the proceedings before the court, on the basis of which the court made the orders sought to be set aside. Yes, ma'am. Yes, ma'am.
Accuse that member of being, when the decision that is taken here is a collective decision by you isolate one member in your decision and accuse that member of being privy to a constitutional breach. You think that it's the proper thing for us to do is what?
Well, first of all, it's not a proper inference from the affidavit because the person whose judicial the judicial circular does not make reference to the full membership of the panel. Oh yes, yes, because she was named in the circular. The rest of the panel was not named there. Yes, but I'm giving the background to that application.
I think it's not really civil.
Well, I'm not accusing, and to turn it into an accusation, it's not a fair inference to be drawn from the affidavit. Maybe my lord is borrowing his words, and then I have to answer.
Sorry, are you able to allow the court to tell you something?
Oh.
It's the proper practice at the bar is when the judge starts speaking, you stop. Do you not appreciate that?
Oh, my lady, I don't think my lord thought I interrupted him. I was just responding.
I beg your pardon.
Then you shall. It's a prosper. I don't think you should. My lord, I don't think.
Are you able to let my lord land before you start speaking? So we can have an orderly conduct for today's event.
So that's my worry and discussion. But when the court says, I don't think it's proper to isolate from them. Whether she knew or she don't know. I say, part of it. It is actually accusations across the board. You should know better.
My lord.
The other friend has raised an objection. I would have thought that the gentleman did things to have done to have been sealed. Because what we have done is to isolate these people members of the panel and accuse them of constitutional breaches. And you know how serious that is.
My lord, can I answer?
I think
Very well. So, but I'm saying that it's not a fair inference from the affidavit, and with all due respect, we refer to a circular that had nothing to do with the panel, and so it wouldn't have been right. I would have been misrepresenting the circular if I put it in those terms.
Yes, Mr. Abedu, can we hear you on this preliminary point? He's done. He's done.
No, but is he done?
But yes, he's done.
I totally associate myself with the concerns raised by the Attorney General, and I have nothing more useful to add.
Second. Sorry.
Now, Mr. Sorry, can we hear you on your objection?
Of the president arises from some of
that, my lord, on the stream, what?
Right to my lady the Chief Justice, to him being impaneled in this matter arises from the fact that at a point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings
said,
and the
no, I think you said enough. Kindly resume your seat.
Very well, my lady.
Let's go.
No. Don't call.
This is like just case communication with the fellowship use.
Registrar.
My Lord, with respect.
You gave your You gave your privilege of stand. Please stand. You gave your privilege of addressing the court to your junior, so we will not hear you. Not on these matters.
My Lord,
we will not hear you.
I apologize. I was sitting in Parliament. When the speaker is talking, you sit. You don't stand. So when I make this mistake, accept it. Yes. And my junior,
please, Mr. Gatti, we will not listen to you at this point.
Okay. When you're ready, when now you decide that you are.
Mr. Gatti, we will not listen to you.
I'm just saying that, my Lord, if
the court will rise now to give a.
Then you.
All rise.
No,